Good evening, folks. We will go ahead and call this April 23rd workshop to order. The purpose of this workshop has four items. Public records, Article 2, Section 8 of the Florida Constitution. The second item is Article 2, Section 8 of the Florida Constitution. And the third item is Part 3, Chapter 112 of the Florida Statutes. And we will also finally go over public meetings. We have one commissioner in attendance, Commissioner Hersom, and we will go ahead and get started. Miss Judy.
Okay.
You got a green light, so it's...
I have a green light.
Oh, and I see activity.
Did you say the
thing is back there?
Ah,
okay.
maybe if you point it, there we go.
Okay, good evening. We're going to talk about Florida Public Records Law this evening. Our agenda is what is a public record, public records requests, records retention and disposal, and concluding thoughts. What is a public record? Get situated here. Section 119 of the Florida Statutes, definition of public record is all documents, papers, letters, maps, books, tapes, photographs, films, sound, recordings, data processing software, or other material, and regardless of the physical form, characteristics or means of transmission made or received pursuant to law or ordinance or in connection with the transaction of official businesses by the city. Florida Supreme Court in 1980 described public records as all materials made or received by a city in connection with official business, which are used to perpetuate, communicate, or formalize knowledge. In 1979, Florida Supreme Court defined it as all materials regardless of whether they are in final form. Florida 1st District Court of Appeal, 2009, then expanded that to include not limited to traditional rent documents, includes tapes, photographs, recordings, and items in digital form.
Miss Judy, would you, for Commissioner Hersom's gratification, explain the notes? If he writes notes up here, can someone ask to see those notes?
Yes,
if no one else, if he doesn't share them with anyone else?
Yes.
So if he's writing up here, personal notes,
yes,
and he doesn't share them with anybody else, someone can still say, hey, I see you writing, I want to see that.
that is correct.
Okay.
And it could be a happy birthday note to someone. But the way that we will handle that is if someone requests that, then if you'll bring it up to the city clerk and let me look at it, and if it is a public record, then we will make a copy of it. And if not, with your pleasure, we will go ahead and show it to whoever has asked for it, because you can defend it. If we don't show it, then it's the attorneys would have a difficult time defending it. Courtney, Attorney Johnson.
Right. So there's certainly an argument to be made if the intention of your personal notes are not meant to communicate, perpetuate knowledge about city business. So anytime you're intending to use those notes for something, that's what makes it a
Public record.
So,
If that makes sense.
yeah, so if in the course of a discussion, if I'm taking notes on something, those potentially become public record.
Right.
That's
So you're
correct.
taking notes on something because you're kind of jotting down your thoughts on what you're going to say, and you're using those notes to
Perpetuate.
that knowledge, and now you're using it.
Okay.
So if I'm taking notes on something and I never
Okay, thank you.
Okay. Drafts and notes. There is no unfinished business exception. Public records include interoffice or intra-office memorandum between government employees and or officials. Working drafts if they are circulated for review or comment. Notes to the extent they perpetuate, communicate, or formalize knowledge. Notes intended solely for personal use have been determined to not be public records. If the notes were taken to confirm or summarize what was discussed at a meeting or discussion regarding city business, then they were likely a public record because the notes formalized knowledge. Electronic and computer records. Electronic databases. Information stored in a public agency's computer system. If a city acquires an electronic record-keeping system, the city must consider whether the system is capable of providing data in a common digital format. Email and text messages made or received by city officers, elected officials, and employees in connection with official business. This applies regardless of the device, computer, tablet, smartphone, that is used. Social media, posts on Facebook, Twitter, Instagram, LinkedIn, YouTube, etc.
Commissioner Hertzman, have you had a chance yet to link your commissioner Facebook account to the city's archive?
No, I have not.
Because that will make everybody feel a whole lot more comfortable once you do that. Because then the city will automatically back up all of that information. The problem that you have as a commissioner is sometimes you will comment, like like somebody's post. That's public record, and it's a public statement. So if there's a Facebook thread of 300 comments and a previous commissioner has written something, and then you come in and say something or even like someone's comment, then that's potentially a sunshine violation. And then later on it gets nasty and they delete the whole thing. Then we have no record of it.
Sure.
So especially on your commissioner page, that'll help mitigate some of those issues, and it'll happen automatically and you won't have to think about it.
Right.
So Amy is the person to see
Okay.
for that.
Form of the record is irrelevant. Key is whether the record has been created, maintained, or received by an official, employee, or agent of the city and is related to official business. Some of the examples are documents created on personal computers, emails and texts on personal computers and devices, records of personal phone calls made on city-issued cell phones. Agencies subject to public laws record include government body to include its elected officials, employees, and agents. Advisory boards. Private entities created by a public entity, and that would be like a community redevelopment agency, utility, and other authorities. Private entities doing business with the entity, with the city, receiving public funds. Contracts require compliance with public records law. Attorney Johnson is familiar with that, and it is always included in the contracts. Does not apply to all private entities' records, essentially only those related to public business. Public record requests. Article 1, Section 24 of Florida Constitution. Every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, officer, or employee of the state, or persons acting on their behalf, except with respect to records exempted pursuant to this section or specifically made confidential by this Constitution. Chapter 119 of the Florida Statutes provides the public with the right to examine and review records of the state and local governments, and in some instances provide private entities. Okay then. Florida's public records law. Record must be disclosed and made available for inspection unless the document, material, or item is not a public record, is subject to an exemption, does not exist, never existed but has met retention guidelines and been destroyed under an established retention management policy. In those instances, please contact your agency, which is your city clerk, public records custodian. We can, if you're not, the important thing is to respond, and then we can check and to see if it has met any of that criteria. And just some personal advice: don't avoid saying no. Avoid saying, "Oh, I don't have it." You have to talk to the city clerk. You have to speak with the city attorney. Your response should be, "What are you requesting, and how do you want to receive it?" You don't. They're not required. Any requester is not required to tell you their name, the agency they work for, their phone number, their email. Some will just say, "I'll come and pick it up at the office." So just have the attitude of, we have a public record. We will get it to you as quickly as we can. Section 119.07, Florida statutes: every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so at any reasonable time, under reasonable conditions, and under supervision by the custodian of the public records. And what basically that is saying as well is if we have someone that comes in and requests to see our resolution, book of resolutions, there will be staff there with the requester as they go through the records, because we do not want records to go missing because someone has accidentally or incidentally looked at them and left with the record. So, I'm going to expound on that a little. Every person, although the city has a designated records custodian, the city clerk, the law provides that anyone who has in their possession the requested record is required to provide. Any person, encompassing and without any limitation, any individual, group, or company. The person to whom the request is made cannot require the request be in writing, give a name, contact information, or include a reason for the request. At any reasonable time, under reasonable conditions, the reasonable time needed to locate the record and make available for review or copying. Reasonable conditions has been interpreted by the courts to refer to reasonable conditions required to preserve and protect the document from destruction or alteration. It does not refer to conditions that must be fulfilled prior to record being provided. Okay, my papers are getting... The law requires that...
I'm sorry, Ms.
No,
Judy,
go ahead.
I thought you were
No.
looking for something. My basic response when somebody asks me is absolutely, we're going to get that to you. And then I push it right to Miss Judy. And I say, just contact our city clerk and she will help you out. And that means I'm not saying no, I'm just telling you exactly who to go to get it.
Okay. The law requires that the record custodian promptly acknowledges a request and respond in good faith. Acknowledgement of receipt of the request should be done as soon as possible, at least within 24 business hours of receipt. Typically, the acknowledgement is by written response, letter, or email. The acknowledgement is not the response to the request, but only a statement that the request has been received and the city is working to respond. Duty to respond in good faith includes making reasonable efforts to determine from other officers, employees, or agents of the city that the record exists and where it is located. And I usually do that even if it's on the weekend or whatever. I have a response, and I will respond at a confirmation of the request. And then I, depend upon if it's the building department or the planning and zoning or the utilities, then I email so that we have a record that individual, the request, and I also, in the first response, I provide the department head, the agency custodian, the liaison, as well with phone numbers and emails. So there's, the requester has 3 people always that they can contact if they have any questions or concerns. The Public Records Law does not establish a specific time frame for responding to requests. According to the Florida Supreme Court, the time to respond is the limited reasonable time allowed the custodian to retrieve the records and delete those portions of the record the custodian exerts are exempt. The reasonable time to respond, then, is ultimately determined based on the nature of the request and the volume of documents involved. An unjustified or arbitrary delay in producing documents has been deemed an unlawful refusal to provide public records, and such as a 45-day delay in responding. And we certainly don't want to do that. The city may not refuse to allow inspection of a public record on grounds. The city may not refuse to allow inspection of a public record on the grounds that the record is not in the possession of the official records custodian, but is in the possession of another city official or employee. Similarly, the city may not refuse to provide a public record it may have on the grounds that is maintained by another public agency. The city is required to provide a copy of any non-exempt public record that satisfies the request. Providing a copy, however, can be conditioned upon the requester paying the statutory fees for obtaining and copying the record. Current copy charges are 15 cents per page, but our policy allows 10 pages with no charge. Costs for producing records can include a reasonable charge for the actual labor costs if fulfillment of the request requires extensive use of information technology resources or extensive clerical or supervisory assistance or both. And we have had that happen. Oh, here's my light. That's what I was looking for. Sorry. If the request seeks documents that are exempt or are subject to an exemption, then the custodian is obligated to state the basis for the exemption, including the applicable statute that establishes the claimed exemption. In other words, I have to refer to the statute that law enforcement, address, social security numbers, that those types of things are exemptions. And there are so many, there's just so many. So if the records contains information that is exempt from disclosure and other information that is not, the custodian must redact the exempt information and provide the redacted record to the requester. In general, the city or the custodian is not liable to a person if records subject to the exemption are wrongfully produced, provided, however, the failure to comply with the exemption was by mistake and not an intentional act. All exemptions are created by the legislature and fall into one or two categories. Records that are exempt in their entirety, autopsy photographs, active criminal investigation materials, or records that contain exempt information, home addresses, and telephone numbers of certain individuals. Exemptions are strictly construed. Exemptions can apply retroactively if the legislature adopted the exemption with intent for it to apply retroactively. Most exemptions have a sunset provision, and therefore, unless renewed by the legislature, they will expire. There are literally hundreds of exemptions that are applicable to the Public Records Law. Some of the more common ones the city deals with are Social Security numbers, personal information, home address, phone numbers, birth date of police, fire code enforcement, and human resources personnel and their families, active criminal investigation materials, medical information and records, pending internal investigation records, security system information and plans. The Public Records Law requires the city to produce for review and copying a public record. It does not require the city to create a document that does not exist. Require the city to answer any questions about the document or the matters contained in it. The city is required to provide the record in the medium or format requested, but only if the city maintains the record in the specific medium or format. And that is just saying if it's, we use what we have, we do not have to change the format. Although not required by the law, the city is authorized to establish a process to allow remote access to public records, and we have talked about that. I'm running out of time here. At least 5 business days before filing, protecting against litigation. At least 5 business days before filing suit, read denial of a public records request. The complainant must provide written notice identifying the public record to the city's custodian or public records. The local government, in order to be protected, and this is, must prominently post the contact information for the custodian of public records. In the government's primary administrative building, which we have, and on the government's website, if it has one, and we have done that. Attorney Johnson, do you want me to continue?
Yeah, absolutely.
Okay, I'm getting. The complainant must not have requested the public record or brought suit for an improper purpose, primarily to cause a violation of Chapter 119 or an frivolous purpose, which happens. Recent trend in public records litigation. Requests, sometimes burdensome, of untrained or unaware employees, followed immediately by litigation seeking attorney fees. Requests often test the nuances of the law, giving the municipal employee every opportunity to make a mistake, even unwillingly. And there's an example here of a town of Gulfstream, beach community of 900 people and a municipal staff of 4 people. They received, in less than a year, the town received 1,100 public records requests. 1,100.
There was, not to interrupt you,
No, go
but
ahead.
there's a lot of criticism from local governments that there kind of was no good faith exemption in the statute. And so this, even if we're trying our best, but we make a mistake, we can still be on the hook for attorney's fees, and it's just not fair, especially in some of these cases where entities and private individuals are basically going local government to local government, trying to catch people in order to collect attorney's fees. And so there was a case out of Jacksonville where the court said, you know what, enough, I'm going to read in this good faith provision. And the Florida Supreme Court came back and said, nope, unless it's in there, you don't get to legislate that. And so this was our legislature's response to that. So it's not entirely a good faith exception, but it does say that if you follow these rules and then we can find that they were doing it for a frivolous purpose, they can't. And so luckily we've got staff who's on top of that, and posting everywhere they need to and following those rules. So we feel pretty confident.
And our next section, and we have really gone through this quickly, records retention and disposal. Specific issues relate to maintenance, storage, retention, and disposal of public records. All records related to official business in any manner should be maintained by city staff. Records documents obtained by city commission members or members of appointed boards. Notes taken by city commission members or members of appointed boards. Correspondence prepared or received by city commission members or members of appointed boards. Text messages received or sent and related to official business. Email messages received or sent and related to official business. The law requires the State of Florida Division of Library and Information Services to establish retention schedules and disposal procedures for public records. Each city should have adopted a records management policy and procedure that implements the established retention schedules and disposal procedures. The goal is to balance the city's need to manage, store, and access public records with the public's right to review records on timely issues related to official business. Best practices. Know who the custodian of records is. Immediately acknowledge requests received. Do not insist the individual identify themselves, their affiliation, or their motive before fulfilling their request. Do not insist the individual reduce the request to writing. Charges must be reasonable and correlate to efforts expended in producing record. No flat fees or excessive charges. And if you have any questions, ask your city clerk or city attorney. And that concludes my presentation. You have any questions?
Thank you, Ms. Judy. You have any questions, Commissioner?
I think it summarizes, if I get one, acknowledge it, and then pass it on to Ms. Judy.
You're a wonderful student. That's exactly right.
Is that TV off?
Good eye. Good eye.
Well, first I thought it was the presentation, not the TV.
Probably
I'm
'cause
sure
I
Dallas
hit
will
my
fix
head
that
on it
later.
all the time. It's going to drive Dallas crazy now the rest of the meeting. You know that, right? He's going to be
Yeah.
sitting there staring at it.
Yeah, I do. Okay. Good evening, Mr. Mayor, Commissioner Hersham. Our city clerk obviously just did public records, so now we're going to do sunshine law and ethics. And we understand that this is kind of a crash course, and we are throwing a lot at you, hard and fast. So kind of the goal for tonight is issue spotting for you. So if it comes up, you can ask questions. No one's expecting you to memorize anything. Well, Judy's is a little more important. No one's expecting you to memorize any of my stuff tonight, but just know that if it comes up, that you can ask more questions. Often with things like this, after the fact or after something comes up, questions will come up. So obviously feel free to contact us, and we're happy to always talk about it. And obviously with your time on the plan board, some of this will be repeat for you. Okay, sunshine law. All meetings in which official acts are taken or public business is transmitted are public or transacted are public meetings open to the public at all times. Commissions, boards, committees conduct the people's business, and the laws are there to ensure that deliberations and actions of boards and commissions are conducted in the public. Protects the public from closed-door decision-making and provides a right of access to government meetings. And this is applicable to meetings of boards, commissions, and committees created by formal action of the governing body. It applies to 2 or more members of the same body or to a single member with delegated authority. So you are free to talk to anyone on the plan board about city business because you're not part of the same board or committee. It's not a sunshine law violation, but you cannot talk to your other commissioners. It's my one piece of technology. It's the ringing phone. The use of a telephone does not remove a conversation from the requirements of the law. And you cannot use your computers, private computers, to conduct discussions regarding the board. Okay, so what is a meeting? A meeting is a discussion of 2 or more members of the same board or commission on some matter that may foreseeably come before that board or commission. So it doesn't have to be something that's set for a vote, doesn't have to be on a future agenda, but if it's something that foreseeably would be something that would be in your purview or jurisdiction, then it would be subject to the sunshine law. So this includes memorandums and letters, emails, text messages, daisy chain, discussions before or after meetings, social media posts, as the mayor was kind of referencing earlier. So it doesn't have to be this traditional idea of a meeting where you're sitting down with another commissioner. It can be a lot of things that you wouldn't normally think of as a meeting, especially the daisy chain. Sometimes daisy chains happen
By accident.
by accident, and then it's not really a daisy chain because you're not intending to do that.
Just understand, though, Commissioner, that if somebody does a public records request and sees that you spent 15 minutes on the phone with another commissioner, even if you spend 30 seconds on the phone with another commissioner, it's really about the perception than it is about they'll see us at Hitchcock's all together. They see us, you run into each other, that kind of stuff, and every time that happens, we run the risk of perception as reality. So.
And the mayor is stealing my thunder
Oh
because
my
that's how we
goodness.
start the ethics training, is that there's kind of two rules in ethics. There's the actual formal ethical rules and things that we find in the Florida statute, and then you've got your appearance of impropriety. And so while the appearance of impropriety is probably not going to land you a fine or in jail or losing your position here, it certainly can change the way the public perceives you, and certainly doesn't prohibit them from filing an ethics complaint against you, a lawsuit against the city. So it's just something to be mindful of. So the Sunshine Law, the basic requirements when it all boils down to it is that the public has to be given reasonable notice of meetings. All the meetings have to be open to the public, and you've got to have minutes that are promptly recorded. That last one you don't really have to worry about because luckily you've got a city clerk who takes care of that quickly for you, and so it's never something you need to worry. So what is reasonable notice? It's going to be a reasonable time, a reasonable manner of how you're telling people about when the meeting will be. The location and the time of the meeting have to be included in the notice, and you've got to include the board or committee, which board or committee it is. So, open to the public means it's got to be located within Alachua County. Really, oh, sorry, I put Archer there. I apologize. City of Newberry, not City of Archer. There might be some exceptions. Yeah, it could be outside somewhere in the county, but really, if it's a City of Newberry meeting, it needs to be here in the City of Newberry. It has to be at a fixed location. You as a commission can't go traveling to different locations, because if a member of the public wants to come, they have to know exactly where they can go. No physical or psychological barriers to attending. There was a case once where a city had a cafeteria in the city, and the commission had a habit of, before commission meetings, they would all go and have dinner, and they would invite the public to come and kind of informally chat with them and tell them their thoughts on the city. And some citizens complained because they said they couldn't afford to eat in the cafeteria. So they felt like these meetings were happening, and even though they were open to the public, they weren't really open, because if you couldn't afford to eat there, then you couldn't come in and participate. The inaudible utterance rule. During a meeting, the public not only has a right to be present, but they have a right to hear what's happening. So basically no whispering. If you're having a conversation, if you're having a thought, they need to be able to understand what you're saying.
This one's a real tough one because a lot of times, especially commissioners will enter and they'll say, "What are we talking about? Where are we in the agenda?" And if they didn't hear, that could be a problem. So obviously we try to be collegial in here, but if it's distracting you and people out there can't hear it, then they would have a legitimate claim to say, "Wait a minute, those guys I can see them talking, and I can't hear what they're saying." Normally, it is just a, "Hey, where is this? Do you have it?"
Or pass the candy.
Or pass the candy. Or pass the birthday card or something like that. But those folks out there don't always know that. And sometimes, so, if the conversation goes on for a long time, I'll usually try to interject a bit of levity in it so that it doesn't turn serious. But that's what's going on when I do that. It's my gentle reminder, like, be careful, guys.
The public must be allowed to attend the meetings. Meetings can't be held at exclusive or inaccessible facilities, and no evasive actions are allowed. Circulating kind of a written position paper to the commission and asking them to send you back their thoughts on it, using staff, lobbyists, or other means to seek other members' positions about the issues. If you want to talk about it with your fellow commissioners, that's great, and we welcome it, but we welcome it up here at the dais. And if it's a topic that you think, this is really something that I'm going to feel rushed at a meeting and I don't feel like I'm adequately able to talk about this with my fellow commissioners, then that's what we have workshops for. Okay. Kind of to piggyback on what your city clerk was saying, the Sunshine Law, much like public records, is broadly construed, and while there are exemptions, they're very narrowly construed. So if in doubt, you can assume that the Sunshine Law applies and go ahead and follow through. So how does a violation of the Sunshine affect the validity of the action taken? Any official action of a public board, agency, or committee which does not comply with the requirements of the Sunshine Law is void. So if you're talking to another commissioner outside of a public meeting, let's say on a major project the city's about to undertake, and we just entered into a contract for that, well, now that contract is void because you violated the Sunshine Law. Obviously, that's a pretty harsh result. And so we have in Florida what we call a toller cure, and so you can try to fix the violation by having a separate independent meeting where you discuss that item. It can't just be a perfunctory rubber stamp. It has to kind of be full and frank conversation on the merits, but you can cure that violation and save the action. But just because you save the ordinance, you save the contract, you save whatever the action is, it doesn't mean that you've shielded the city or yourself from a violation of the Sunshine. So you could still be in trouble and face a fine even though we saved whatever the action was. Okay, so penalties and sanctions. If you knowingly violate the Sunshine, it's a criminal misdemeanor. The action is vacated, as we talked about before, and the city can be responsible for the attorney's fees of the party who brings the suit against the city. Okay, so that was a really quick overview of Sunshine. Do you have any questions?
I think I'm good. I've got some experience with
Yeah.
planning and zoning
It's
and,
not your
and
first
the
rodeo.
university.
Yeah, okay. Yeah. Okay, code of ethics. So as we were saying before, we've kind of got two here. We've got the minimum legal standards that you have to live by, and then we've got the appearance of impropriety, or what we often call good government standards. So a public office is a public trust. The people have the right to secure and sustain that trust against abuse. In a situation which even attempts to dishonor is ethically wrong. So, best practice for effective compliance: obtain a packet of ethics laws and policies with a summary of key provisions. The Florida Commission on Ethics does a fabulous job of that. And if you want, we can get you a copy of that, but I think it's kind of a great summary of what's in there. Attend annual training each calendar year. The Florida legislature has kind of taken that out of your hands. As a commissioner, you are required every calendar year, to have 4 hours of training, which is 1 hour of public records, 1 hour of Sunshine, and 2 hours of ethics. You can always come to the city attorney's office and seek either kind of informal opinions over the phone, or you can request that we memorialize something in writing to you. You can also call the Florida Commission on Ethics. They have a hotline number that you can call and speak to one of their staff attorneys. You don't have to identify yourself, but you can kind of go over a fact pattern. What they say is not binding over the phone, but usually can give you a good idea. You can also write them a formal letter, and we can help you with that through the city, where they will issue an advisory opinion on what your issue is, and that is binding as long as you're honest with them and give them the facts, that when they issue you an opinion, that's kind of the final ruling. Penalties. You can be removed from office. You can be suspended from office. You can receive a public censure and reprimand. You can forfeit up to 1/3 of your salary for a year. Fines up to $10,000. And if you have benefited financially in any way from your unethical conduct, you can be forced to pay restitution in addition to all of that. Okay. So what is a conflict of interest? A conflict of interest occurs when a public official's personal activities or relationships interfere with how the public official does their job. And these can decrease the public's trust in government. They can lead to misuse of office, corrupt misuse of official position, improper contractual relationships, improper disclosure or use of inside information, nepotism, voting conflict. So, nepotism. Employees, officials, or advisory board members are prohibited from appointing, employing, promoting, advancing, or advocating for any of those things on the list to benefit any relative or a spouse or domestic partner. So you as a commission really only have official say-so over 3 employees. Mr. Walker, your city clerk, and your city manager. Everybody else, for the most part, falls under the purview of your city manager, who's in charge of the employees. But you still cannot advocate for the employment of any of your relatives to the city. I guess in general, let me back up. The word relative changes throughout Chapter 112, which is where all the Florida ethics laws are. So I won't get into specific definitions tonight for you. Just know that it changes depending on what activity it is, and a lot of this stuff is very fact-driven. So if you've got a question on any of this and whether or not a cousin counts that time, or a minor child, or a grandparent, brother-in-law, things like that, just ask us and we'll be able to tell you. Influence laws. You may not solicit or accept anything of value if it is given to influence a vote or other action of that individual. Really kind of tantamount to bribery. There is no threshold amount. So someone buying you a cup of coffee, that's $2. Doesn't matter that it's a low dollar amount. If it's meant to influence you, you cannot accept it. And the test is whether you know or with the exercise of reasonable care should know. So you're a smart guy, you can't put your head in the sand. So the gift law for reporting individuals, which includes all you as the commission, is you may not solicit any gifts from lobbyists, political committees, or vendors for yourself or your immediate family, regardless of value. So you cannot ask for a cup of coffee from anyone basically that does business with the city or attempts to lobby the city. So a lobbyist, per Florida statutes, is a person who is paid to influence the city of Newberry, in this case, within the prior 12 months to encourage the passage, defeat, or modification of any proposal. And a vendor is a business entity doing business with the city of Newberry, such as renting, leasing, or selling any realty goods or services. A gift is anything of value to a donee, yourself, or for your benefit, for which equal or greater consideration is not given within 90 days. So somebody gives you a gift, and on day 85, you say, oh, yeah, that guy might be a lobbyist. That guy might be a vendor. There might be a situation. You have 90 days to pay down that gift. So if someone gives you Gator tickets and they were $50 and you decide you actually couldn't have accepted those, you can go back and pay the $50 for that. So they give you a little bit of wiggle room. So examples of gifts. They take a pretty broad definition of what's a gift. So use of vacation home, preferential loan rate not available to the general public, personal or professional services, free publicity, food and beverage, tickets to an event. Kind of the trick here too on gifts is when you're calculating the value of a gift. The best example is always Gator games. If someone offers you Champions Club seats, the face value might still say $50 or so. I don't even know what face value is, but we'll have a relatively low number when actually you can't sit in Champions Club unless someone has made a rather sizable donation. So you've got to figure out what that price is too and add it. You also can't separate gifts out. If someone offers you a vacation and you take it, you can't say, well, the food was only this amount and the lodging was only this amount. If the gift is a trip, you got to count that all. So Quarterly, you must report all gifts over $100 unless it's from a relative. And annually, you must report gifts over $100 from another government. There are exceptions to the definition of gift: political contributions authorized by state and federal law, gifts from relatives or members of your household, personal gifts over $100 if given by a personal friend or coworker, and the motivation of the gift is that of friendship or social relationship. Awards for civic or professional achievement, inheritance, honorariums, but you may not, and this might apply to you since you are a professor, you may not solicit honorariums, speeches, if it's related to this office. You can still do it in your private practice. And you can still get expenses paid, things like that, that you usually would. So what is absolutely prohibited is no person or entity shall offer, give, or agree to give an official or employee a gift of any value, and no official or employee shall accept any gift because of an official action taken or to be taken or which could be taken, a legal duty performed or to be performed or which could be performed, and a legal duty violated or to be violated. So the gifts law is kind of complicated and really kind of factually based. So if you've got any questions on the gift stuff, let me know. Voting conflict of interest, when you cannot vote and when you're excused from voting. Protects against conflicts of interest and establishes standards for the conduct of elected officials and government employees in situations where conflicts may exist. So the true test is whether or not you would have a special gain or loss for yourself, your relatives, your business associates, or your principal. If you have a voting conflict, you cannot vote, and you must declare at the meeting that you have a conflict. You must complete a form that we get from the Commission on Ethics, and then that's got to be filed with our meeting minutes. Florida law is a little odd, and it says that you may participate in an action in which you have a conflict and may not vote if you publicly disclose your conflict. Some people are very uncomfortable with that, and they won't participate because it kind of goes back to the appearance of impropriety. Some, I believe Commissioner Coleman, usually leaves the room when it's come up. Like, not only steps down from the dais, but steps out and waits for someone to come get him. So that's kind of personal preference for you, but technically the law says it is a good idea, but technically the law says that you may participate, but sometimes that's hard to explain to others why you're not allowed to vote, but you can sit up here and try to influence everyone.
And correct me if I'm wrong, Courtney, but there are limitations about when you're allowed not to vote. So the law is, unless you meet the criteria, you are expected to vote. So it's generally a good idea to have a conversation about that ahead of time to find out if somebody could have the reverse charge and say, well, you claimed a conflict of interest when there really was none because you just didn't want to have to vote on that one, and so you abrogated your responsibility under a false pretense. So it kind of go both ways.
Absolutely. So yeah, he's right. The Florida law is very specific. Unless you have a conflict, if you are present in the commission chambers, you vote. And the idea is kind of twofold. One, so that people aren't intimidating you not to vote. And two, so that you don't have commissioners kind of shirking their duties because something might be kind of controversial and they say, you know what, I'm just going to abstain from this one. I'm just going to not be present. So if you think that there's a voting conflict, you can certainly, sometimes things don't occur to you until you're sitting in a meeting. But if you think of it ahead of time, it's better to go ahead and let us know. We can research the issue and we can get you a written opinion either way. So if there's not a conflict, you can still feel comfortable to announce to everyone, I thought there might be a conflict. I called city staff. This is the answer. So I will be voting, but I'd like to, make a record for the minutes. And we're running out of time, so I'm going to move fast. But there's a specific definition of how you can determine if something's special and whether or not there's actually a voting conflict. There's several tests and factors we can look at there. Doing business with one's own agency, essentially in your kind of private life, your business, you can't be doing business with the city. Makes sense. Or for your spouse or minor children. So you're prohibited from directly or indirectly purchasing, renting, or leasing realty goods or services from the city from a business owned by the officer or employee, or a spouse, or a child who has a material interest. So it's usually not enough that your child works for that business, but does your child have stock options? Is your child a director in that business? And it prohibits you from acting in a private capacity to rent, lease, or sell any realty goods or services to the city. There are exceptions to this, but I don't think you have any current, so we'll just go ahead and skip that now. That's just an example. Misuse of public position. This is the thing that gets the most people in trouble every year. The Commission on Ethics always gives us statistics at the end of the year, and the vast majority of people who get in trouble with Commission on Ethics is misuse of public position. So I will read this one to you. No public officer shall corruptly use or attempt to use his or her official position or any property or resource which may be within his or her trust, or perform his or her official duties to secure a special privilege, benefit, or exemption for himself, herself, or others. Just going to skip that. So a big example of this is commissioners trying to get out of speeding tickets. Don't you know who I am? You can't write me a ticket. Commissioners who use their commissioner business cards to try to get special favor, get special treatment. Commissioners who want to use city property for their business or their own personal use. And this guy bribed city employees with NASCAR tickets and pay raises to harass his ex-wife's new husband with code enforcement violations. So you can't do that. Financial disclosures, I'm sure they've talked to you, but you've got to fill out financial disclosures annually. That's what it looks like. You have to sign an oath that what you're giving to them is true and correct information. If you fail to file, there is a fine. They can come after you for 20 years. So it used to be that people wouldn't necessarily do it. They would leave office and they wouldn't pay the fine because they thought, well, I'm out of office. What are they going to do? They will continue to come after you now. So, questions, concerns, comments, compliments?
Commissioner.
Ask you first.
Ask me first. I'm not saying I can't fix problems. I enjoy fixing problems, but I'm better on the front end than after something has already happened. So,
He has a
you.
gift of summary.
Yeah.
And Courtney, do we have anybody else that was supposed to present, but we ran out of time, or did
Nope,
we cover
that was it.
We got it all.
Yep.
All right. Commissioner, have any last questions?
Ask for permission rather than forgiveness.
All right. We will close the workshop, and we will adjourn the meeting.